All right, I think we have everyone populated into the webinar who was in our waiting room. So good afternoon, everyone, and welcome to our April in the Boardroom on county funding of nonprofit organizations. Certainly an issue that I think since 2017 there has been a lot of confusion about, a lot of questions about. So we have Andy Phillips with us today who is going to clarify all of the questions folks have and all of the confusion folks have about county funding of nonprofit organizations. Before I turn it over to Andy, I just want to give a few reminders to folks. First of all, if you have questions throughout the webinar, please feel free to put them in either the chat function or the Q&A function. Andy and now Malia is joining us as well. Andy, Malia, and I will be monitoring both the chat and the Q&A throughout the webinar. For those questions that we don't get to while the webinar is formally in progress, we will get to all of the questions at the end of the formal presentation. The other thing I will mention is this webinar is going to be recorded and will be placed on the WCA website along with the PowerPoint, hopefully by the end of the day today, pending schedules. So again, if you need to refer back to the slides or to what was said as part of the webinar, it will be made available on the WCA website. So with that, I think since this is, going to be a pretty popular webinar, and I think we anticipate several questions, I'm going to stop with the introductory remarks at this time, turn it over to Andy and Malia, who are going to walk us through this issue. Andy,
Thank you,
Malia?
Sarah. Appreciate it. And as Sarah mentioned, I'm Andy Phillips, and my partner in crime today is Malia Malone. Malia has a ton of experience working in the Corporation Counsel's office, so she has boots on the ground experience dealing with questions surrounding county authority to do certain things. Because Malia, correct me if I'm wrong, but it's my hunch that you've probably, in the course of your career, been asked some strange questions about what county boards may or may not do at certain times. Is that a fair assessment?
That is very fair, Andy. Thank you.
And
Great
so
memory.
Malia can bring that practical advice for us. As Sarah mentioned, this is an issue that has been a topic of conversation for the better part of 8 years, dating back to 2017 when the Attorney General issued an opinion about funding nonprofit organizations. And it seems very simple, and it seems very basic. Can a county appropriate money to support a nonprofit? And as a lawyer, and Malia is a lawyer as well, what we will always say is, well, it depends. And I know nobody likes to hear that lawyer statement, that lawyer answer, but in this circumstance, it's perfectly appropriate. So today we want to walk through that 2017 Attorney General opinion. There were a couple of follow-on analyses that were conducted relating to that opinion. So we're going to talk about the memo that WCA put out immediately following that 2017 release of the Attorney General opinion. We're going to talk about alleged counsel memo that was released in 2021. And then we're going to talk about a memo that WCA put together this past January, which essentially takes all of the analysis, wraps it up into one spot, and then looks at different statutes and different issues that weren't addressed in any of the previous opinions. And I can tell you that as Malia and I were the primary authors on that memo number 2, is that what we wanted is a one-stop shop, if you will, for this analysis so that counties and corporation counsel don't have to refer to 14 different sources to get all of the information. So we tried to encapsulate all the information into that one memo that was released in January. I also want to talk about a particular bill that was introduced last legislative session. In 2023's legislative session, AB 645 made its way through the legislature. And I want to talk about that bill and some of the concerns that WCA had with that bill and why those concerns exist. Because again, this isn't a simple question. This has a lot of different avenues and paths to it that you can go down from a legal authority standpoint. And then finally, I want to round out and have a discussion about the analysis that we undertake as counsel to the WCA, as counsel, special counsel to counties, and that I'm sure your corporation counsel will go through on determining whether a county has the authority to appropriate funds to a nonprofit organization. So let's start with this whole issue of county authority. And this is an important place to start. This is before we get into the specific question that the Attorney General answered in 2017, the specific question of funding nonprofits. it's really important to have this very, very foundational understanding of the nature of county government. And you'll see here that there's a case cited from 1897. Why are we citing a case from 1897? Because the law hasn't changed since 1897. Counties derive their authority from state statute. That's different than cities and villages. Cities and villages derive their authority through their charter ordinance, which is authorized under the Wisconsin Constitution. They have independent home rule authority. The legislature can't do anything about that home rule authority. The legislature has a lot of say over counties. And so it's very important to distinguish between home rule authority as it relates to the power of cities and villages and home rule authority as it relates to the powers of a county. And I put this quote in here because it makes me irritated to see quotes like this, but it's true. Counties are at most but local organizations which for the purposes of civil administration are invested with a few functions characteristic of a corporate existence. The statutes confer upon them all the power that they possess. Very important to remember that. And so fast forward to 1977 from 1897, and we've got this Dane County case. And this was a case involving a county's authority as it relates to certain social service programs. And you had the court in that circumstance saying the power, it's the Supreme Court, the power to carry out a specific program or appropriate funds to support a program must be grounded in independent statutory authority. Okay, so again, from a very, very base level foundational perspective, we take a look at the authority of counties and the nature of county government in particular. Anything you want to add on that, Malia, before we head on to the specific analysis?
No, I will. I'm saving the best for the specific analysis.
Got it. Okay. So 2017, fast forward from 1897 to 1977 to 2017. Every year ends in 7. That's coincidence. I just noticed it now, but every year ends in 7. So Shawano County and their corporation counsel asked the Attorney General, can a county board appropriate funds to support a local food pantry? Okay, the Attorney General took a look at this question, and in analyzing the question, took a look at 59.53 sub 21. In that statute, which is on this slide, the board may establish and operate a program of relief for a specific class or classes of persons residing in that county. Okay, so you'll look at that statute and you say, well, okay, a county has the authority to operate a program of relief for a specific class or classes of persons residing in that county. Isn't a program that is designed to reduce hunger or eliminate hunger, isn't that a program of relief for a specific class of persons within that county? So if that's the case, why is it that it would be problematic for a county board to appropriate funds to a nonprofit agency whose sole mission is to eradicate hunger within the county? I have that last question there though, because this is a very important question. This is where the Attorney General's analysis went. Does this language actually limit a county board's authority? All right, so let's think about it not in terms of an empowerment statute, but perhaps a limitation statute. What do we mean by that? All right, as the Attorney General recognized, 595321 grants the county board the authority to operate its own relief programs, not delegate that authority, not contract away that authority, not assume that that authority is going to be exercised by an independent agency, but it has the ability to operate its own relief programs under that statute. Therefore, the AG determined the statute does not expressly confer authority to appropriate funds to a nonprofit to accomplish the goal of providing food to those in need. And this is a quote from the Attorney General's opinion that gives you an idea of why the Attorney General opined the way that he did back in 2017. Quote, because the statute specifically addresses a county board's authority in this area without granting the authority to make appropriations to nonprofits, county boards do not have the authority, either express or implied, to make such appropriations. And to me, and I think to I know you're about to speak, Malia, but let me get this in quick. To me, that is incredibly limiting in terms of its language and in terms of its scope, if you will. I don't agree with this sentence for a variety of reasons, but I understand where a sentence like this comes from. It comes from that foundational nature of county government. Remember, we saw that the Supreme Court has weighed in on a number of occasions and said you have to have explicit statutory authority as a county to do what it is that you desire to do. And so understanding that foundation, you can understand why the Attorney General said what he did in 2017. Malia, what were you going to say?
Well, I was going to say, and we'll talk more about this later on, but it's very key to also recognize that the Attorney General looked solely at Chapter 59, which is a good place to start because that's the statute that talks about what counties can and cannot do generally. But he limited his analysis to what was contained within that chapter rather than looking throughout the statutes. And we're going to talk more about that later.
That is a great point, Malia, and it's something that I know you and I talk about quite often, is that when we get asked a question or we're confronting an issue about county board authority, it would be awesome if all we had to do was open up the statute books to Chapter 59 and go through Chapter 59 and figure it out. But we know that that's not the case. And unfortunately, I guess fortunately for us, because we're lawyers, so people have to call us with these questions, but unfortunately, that's not how it works. You have to look at Chapter 46, 48, 83, go down the list of all of the statutes, 19 that impact county government, all right? And so counties have this special place for whatever reason in Wisconsin where their duties, authorities, powers, limitations, and so on are sprinkled throughout the statutes. So you're right. The Attorney General's focus on Chapter 59, we think, was a bit too myopic. It was one track. There are other statutes that impact this analysis, which we will get into. All right. So I want to talk now about where the Attorney General said, okay, if you look at the language of 595321, and remember I asked the question, is this a limitation statute, not an empowerment statute? The Attorney General took a look at some other statutes that he viewed them to be empowering statutes, 5953 sub 3, 5953 sub 11 sub C. Those specifically, those statutes in those sections specifically grant a county board the authority to appropriate funds to nonprofit organizations for something other than the operation of a food pantry. And so the Attorney General said, if I look at 5953, which is frankly the human services provision within Chapter 59, if I look at 5953 and the legislature has said, county, you can operate a program for relief within your county, but it doesn't say anything about delegation, doesn't say anything about appropriating money to a nonprofit. But then I look further in 5953 and I see other examples where the legislature specifically said, county, you can appropriate money to a nonprofit for this purpose. Well, then according to the rules of statutory construction, that means the legislature never intended to delegate that authority to counties. And in citing this statutory construction canon or power, if you will, the court or the Attorney General looked at an open records case. And that's unfortunate because public records have nothing to do with county authority. And so we think again that the Attorney General was a bit too myopic in his view of defining the boundaries of county authority here. So again, we've got these two statutes that grant counties specific, explicit authority to appropriate funds. It's important to remember these statutes and others like it, because when we get to the end and talk about the analysis that you as a county or you as your corporation counsel go through, if a specific statute authorizes you to do something and you want to do something explicitly authorized by that statute, you're okay. You don't have to step further in the analysis, okay? So there are situations where it's really clear to us, and it should be to everybody else, that counties have authority to appropriate funds to a nonprofit organization. These are two examples within the statutes. All right, so after OAG 0117 came out, we had all sorts of counties asking questions. And I'm not aware of every practice in every county, but I am aware that there are counties from time to time that appropriate funds to support a nonprofit organization. They appropriate those funds through the county budget. They donate, so to speak, to those nonprofits. And so we had a lot of counties that were concerned about the breadth of OAG 0117 and whether the Attorney General's opinion was going to call those appropriations into question. Now, before we go into that WCA memo number 1 back in 2017, I want to make this point. I don't think it's appropriate, and I think Malia will agree with me. I don't think it's appropriate for counties to collect taxes from property taxpayers and turn around and donate those revenues out to nonprofits indiscriminately. I don't think that is the mission of county government. I don't think that that meets the public purpose test, and I think there are problems with that. So to the extent a county was simply through their budget process supporting a variety of nonprofit organizations just because we think they're good charities, I think that's a problem. Now, distinguish that from what we're about to talk about, which is programs of relief, opportunities for counties to support organizations that do carry out the mission of your particular county, that do serve a public purpose. But again, remember that I don't think it's okay that a county collect tax revenues and then distribute those revenues indiscriminately to nonprofit organizations. Do you agree with me, Malia?
I agree with you, Andy.
All right, good. See, I'm on a roll now. All right. So this WCA memo in response to OAG 0117, a statute that the Attorney General did not address is the home rule statute that exists for counties. Remember, at the beginning, I talked about how cities and villages have home rule authority baked into the Wisconsin Constitution. We as counties don't have that luxury, but we do have statutes on the book granting counties statutory home rule authority. 59.51 sub 1 is an example. 59.03 is another example of a statute granting home rule authority. Just by way of further confusion, I don't know, and nobody's explained to me yet, the real practical difference between statutory home rule authority and constitutional home rule authority in terms of the particular powers. All I know is that every court and attorney general that's ever looked at it has said there's a big difference between the two, but I frankly don't understand what that difference is. I'm putting that out there, so if anybody has an idea of how to adequately explain that difference, please let me know, let Malia know, so that we have the opportunity to share that information with others. That aside, we've got this very broad statement in 59.51 sub 1. And this is referred to, again, as statutory home rule authority or administrative home rule authority. So it says that the board of each county has the authority to exercise any organizational or administrative power subject only to the Constitution and any enactment of the legislature which is of statewide concern. All right. Any organizational or administrative power shall be in addition to all other grants of authority. So this exists independent and supplemental to those powers that we just reviewed in 59.53 of the statutes. And this is really important here at the end. These powers shall be broadly and liberally construed and limited only by express language. So that says to me that counties have the ability to take care of local affairs at the local level as they see fit, so long as it meets all of the requirements of the public purpose doctrine, isn't in contravention of existing state statute or something of that nature. That's the nature of home rule authority, the very nature of it. And so I ask the question, is eliminating hunger not a part of a local government's traditional police powers? What police powers does a county have? That's a great question, probably a topic for a separate in the boardroom discussion. Counties have limited police powers when compared to cities and villages. If we look at city and village police power, they say that cities and villages can regulate in the interest of public safety, health, and welfare of its residents. We don't have that statute in counties. We have 59.54 of the statutes, what kind of gets us there, where we have the ability to regulate, but we don't have broad-based police powers like cities and villages do. So isn't eliminating hunger, though, isn't that part of what we would view as a traditional power of a local government, in this circumstance, a county? And what if we contract with a nonprofit agency to operate a relief program? Isn't that really what we're talking about here in terms of a county program to combat hunger? Because remember, the statute says that the county can have its own program, okay, its own relief program, but the statute doesn't authorize the delegation. Well, we know that counties operate all sorts of programs across the spectrum of different services that counties provide to their citizens. Is it always county employees that are operating those programs? No. We know that, for example, our human service agencies rely upon a lot of outside assistance to operate those programs. So we asked the question in WCA memo number 1, well, okay, Attorney General, I understand what you're saying with a flat out blanket appropriation to a nonprofit. What if we have a contract, an MOU with a nonprofit agency? Does that change the analysis?
And I want to also highlight in that statutory section that provides home rule authority, right before that final section that you already talked about, it says without limitation because of enumeration, which arguably undercuts that canon of statutory construction that the AG was relying upon.
Not only does it arguably undercut, I think it just wipes it out, because that canon of statutory construction doesn't exist in statute. This is in statute. This is the law. And so you're right. I think the Attorney General unfairly ignored that sense. I can understand why the Attorney General reached the conclusion that he did. All right, I get it. But I think that the Attorney General didn't do a deep enough dive on the analysis, frankly. All right, so we had the Attorney General opinion. We had WCA memo number 1 in response. Then we had a 2021 Legislative Council memo. Back in 2021, then Representative Gordon Hintz, who is now the county executive for Winnebago County, asked Ledge Council to address this question. Said to Ledge Council, hey, take a look at this Attorney General opinion. Is this right? Can counties appropriate money to support nonprofit organizations? The Ledge Council, which is the attorneys representing members of the legislature, Ledge Council said that a court, quote, may reasonably conclude that counties do have authority to make a grant to a nonprofit organization for food pantry operation. A couple of words in here that I think make this a loaded conclusion, if you will. Authority to make a grant. Making a grant is different than an outright gift and is different than a contract. A grant may be supported by a grant agreement, in which case we are going to define how the grant funds are going to be used, or a grant may simply be, this is in support of your mission, use it as you see fit, all right? The last part of this conclusion as well is a bit loaded. Food pantry operation. That's important because remember, under 59.53, a county has independent authority to operate a program of relief. And so here, Ledge Council is getting a little closer to the mark in saying, if this ties back to this concept of a county delegating authority to operate a program for relief, is it required to enter into some sort of agreement with that nonprofit to basically connect the dots that the nonprofit is operating a program for relief authorized by the county board? The Ledge Council memo also looks at 59.04 of the statutes. And again, we have that phrase that Malia just pointed out that I think is so important here. The powers are liberally construed in favor of the rights, powers, and privileges of counties to exercise any organizational or administrative power. And then Ledge Council gets into an analysis that the Attorney General never got into. And it kind of flips the script, if you will. The Attorney General said, look, I got to look in the statute. I got to find a specific power that the legislature has authorized. Ledge Council says, no, that's not the analysis that you utilize. What you look at is the very broad powers that counties have authority in 5951 sub 1 and 5903 to exercise. And the only way that they are not empowered to exercise those powers is if the legislature has preempted the county in that particular area. That gets us to the traditional preemption analysis. And that was from the Anchor Bank case from many years ago, where you look at whether the legislature has taken explicit or implicit action to essentially say, counties, you can't regulate in this area. An example would be a topic that we've discussed any number of occasions over the past couple of years, and that is renewable energy regulation. We know that the legislature explicitly preempted county regulation in that area if a project reaches 100 megawatts or more in size. And so again, Ledge Counsel said, let's flip this. We're not going to look for specific statutory authority. We're going to rely upon the broad statutory authority that's granted through administrative home rule in 5903, 5951, and we're going to determine whether there's been preemption in this circumstance. So we had three different analyses out there. We had Attorney General opinion in 2017. We had WCA memo number 1, and we had Ledge Counsel memo in 2021. So when we started taking a look at all of the memos, all of the analyses, and there were still questions floating around out there asking us, asking WCA, what is it that we can really do as it relates to our partnerships out there with nonprofit organizations? That's when WCA said, look, Attolles, can you help us with a second memo that basically pulls everything together and analyzes this question in tremendous detail so that we have an understanding from WCA's perspective of exactly what the analysis is that can be pushed out to corporation counsel and counties to hopefully guide them in their analysis. And so that's what Malia and I undertook. I think I mentioned on the Monday leadership call, by the way, this week that I was excited about this discussion, and I guess that makes me a geek, and I guess that makes Malia a geek because we love talking about this stuff. It's really fun. And so when we look at the question that was posed to us, the first thing we did is said, look, we know that there are all sorts of statutes out there that impact this analysis that frankly, the Attorney General opinion didn't cite to, WCA memo number 1 didn't cite to, and the Ledge Counsel memo didn't cite to. So let's take a look at these other statutes and see what they say. And so Malia, with her corp counsel background, put on her human services hat and started digging through chapter 46 of the statutes. And what did you find, Malia?
Well, it was kind of like opening a present in the morning, like Christmas morning, because as you started to dig down and you could see all of the different ways in which human services specifically are empowered not only to engage in programs of relief, but, and I know we're going to talk about this soon, explicitly it's stated that they can contract with nonprofits to achieve any of those enumerated goals. So there's really quite a plethora of opportunities for counties to contract with nonprofits in the area of human services for the general welfare of the public, some of which has been traditionally done and that was called into question because of that original OAG memo. And so I do think that it was, for me anyway, and again, showing my nerdiness or my dorkiness, which is, I think, one of my best qualities. It was really exciting because you could start to see the pieces get put together where we can look at it this way. And in different counties, in different parts of the state, different needs are going to exist, and they're going to have different opportunities with different potential nonprofits. So it was really actually kind of exciting for me.
So yes, we've got some explicit statutory authority contained within chapter 46 that deals with issues surrounding social and human services, which obviously food insecurity is one of those issues impacting social and human services significantly. All right, so here we've got explicit statutory authority that social services departments, human services departments can do as it relates to combating hunger. And so to carry out these powers, and this is the thing that just amazed me. And it amazed me not because it's there. I figured it was there, and I think all of us had a common understanding it was there. But it amazed me that the Attorney General never looked at these statutes as part of the analysis. And I remember the day, Malia, when you came to my office with that smile on your face and said, you're not going to believe what this statute says. And you read the statute to me. I said, holy cow, because again, we both figured it was out there, but we hadn't looked at that particular statute in a while. But it's right there. In order to ensure the availability of a full range of care and services, Department of Social Services or Human Services can contract, all right? So there's the express authority to delegate certain aspects of operation of these programs, all right? You can contract with public or voluntary agency or others to purchase services in relation to these particular issues. So it's right there in statute. So what does this mean, all right? 4622(1)C authorizes the Department of Social Services or Human Services to furnish services to persons with food insecurity. That counties are empowered to do that through their Department of Social Services or Human Services. Then we got 4622(1E1). So again, same subsection of the statute authorizes that department to contract with other agencies or organizations, including nonprofits, to carry out the provision of those services. So remember when I talked earlier about connecting the dots, there you have the dots connected on this entire analysis. But, and this is very important, we're not talking about a blanket appropriation to a nonprofit agency. We are talking about a delegation of county authority to the nonprofit to carry out the functioning or operation of a county program vis-a-vis a contract. All right. A contract is much different than some sort of blank appropriation. So remember when I talked earlier about if we're talking about a grant, do we have a grant agreement that speaks to the utilization of funding? Well, a grant agreement is no different than a contract, because if the nonprofit doesn't follow the grant agreement, what's the consequence? Kind of get some money back. That's a contract. Here, we may want to have more than a simple grant agreement. We may want to have a specific provider type contract that speaks to exactly what the nonprofit is going to do and speaks to exactly how the nonprofit is going to get paid. So again, you'll see the last bold underlined part of this slide. Counties need to work closely with Corporation Counsel to draft contracts in the provision of these services to make sure those dots are connected adequately. You want to talk a little bit about other examples of statutory authority beyond food pantries, Malia?
Absolutely. And this comes home to me because in my former life as a corp counsel, one of the nonprofits that the county that I worked for wanted to provide funding for was a very popular program, and it was Kinship, that provided mentoring services, kind of like Big Brother, Big Sister, something like that, for youth, perhaps at risk, that maybe only have one parent or are otherwise in need of that type of support. And at that time, to be frank, I opined that based upon the AG's opinion, I was concerned about that appropriation. And luckily, the county decided to go forward with a very detailed contract with Kinship, asking them to provide those services on behalf of children within the county, and with the hopes that that would cover any concern that was raised by the Attorney General. And after going through this analysis, and if we look specifically at 4622 sub 1CA, and we look at mentoring programs like Kinship, I think there's absolutely statutory authority to look at providing those types of appropriations to those types of organizations for those mentoring services. We're also looking at child welfare and the ability for agencies, county agencies, to provide training, supporting foster parents, doing things outside of the normal things that counties do, but that again support the work that those agencies in those local counties need to do. So really there's a wide range of things that can be plugged into these various buckets that we articulated. And I don't think the memo is exhaustive. I mean, it gives sort of opening that door, but it's encouraging counties and corporation councils to look deeper and to see if, especially when there's a political drive within a county to support a particular nonprofit, and you can find that appropriate bucket within the statute and tie it together. I think there's a lot of creative thinking that can be done in a way that is absolutely legally defensible.
Well, and I will say this too, Malia, you are right. There is no way we could have scoured the statutes and found every single example of a statute authorizing a specific way to operate a county program. We couldn't do that because, frankly, it seems like every week I find out there's something new about county government that I didn't know the week before. And I've been doing this for 30 years. You haven't been doing it as long as I have, Malia, but you've been doing it for a long time. And we go week to week learning new stuff about county government. That's part of the joy of working with counties and also part of the frustration, frankly. But there's new stuff that comes up all the time. I say this because this is a circumstance where I think we can learn from our colleagues around the state. So you may have neighboring counties that have good examples of contracts that they enter into to operate certain programs within human services or social services. You may have corporation counsel that have developed a particular MOU form or grant agreement form that you think would be particularly helpful in your county. Have a conversation with your colleagues to understand what your other counterparts across the state are doing. And if you run into a brick wall and say, well, I don't know about this, I still got questions, we're happy to talk with your corporation counsel about that analysis further, because I know that a lot of times they are overburdened and don't have the time necessary to really dig through the statutes. And so we're happy to assist corporation counsel with that analysis. So again, the list isn't exhaustive, but there's a lot out there in terms of authority that exists and was just simply neglected in that Attorney General opinion. And frankly, the Ledge Council follow-up in WCA's first memo talking about that Attorney General opinion. All right. So I want to talk a little bit about a bill that was introduced last legislative session that got quite a bit of traction in the legislature, and nobody could really understand why it is that WCA came out opposed to the bill. 2023 Assembly Bill 645 provided, in relevant part, a county is empowered to or authorized to make payments to a nonprofit organization as defined in section 23-197, which is the section of the statute that just defines what a nonprofit organization is. So a county is authorized to make payments to a nonprofit organization whose primary purpose is to operate a food bank or food pantry and who serves the county as part of that operation. Look at that statute and tell me why in the world WCA would ever be opposed to that statute going on the books. Well, it's, again, the devil's in the details of it here. Let's take a look at the wording of 5953 sub 3 sub C as proposed in Assembly Bill 645. Make payments to a nonprofit organization. Make payments. That doesn't say appropriate grant funds, gift, or anything like that. It says make payments. You can make payments through a grant, through a gift, through a contract, vis-a-vis an MOU, any number of ways that payments are made. So number one, concerned because we think that counties already have the authority to make payments to a nonprofit to operate a relief program like this by virtue of the authority in 46.22 of the statutes. So if you're going to put it in 5953 sub 3C, does that call into question the authority in 4622? And for that matter, if you're going to specifically enumerate in 59.53 the ability of counties to make payments to a nonprofit operating a food pantry, what does that do to other nonprofit organizations operating other programs of relief in the county? Kinship is an example that Malia brought up. Do we have to add kinship to a list? Because remember, the statutory construction argument that the Attorney General relied upon said if you've got a list and your particular power doesn't fall on that list, that means the legislature intentionally excluded that power. So you better be darn sure that that list is complete. Now, the Attorney General didn't make this statutory construction argument up. It's well recognized. It's out there. And so having Assembly Bill 645 on the books, in our mind, in WCA's mind, ran counter to the purpose of the entire analysis, which is to evaluate a county's powers in the totality of all of the statutes and figure out, does a county have the authority to delegate responsibility to operate a relief program to a nonprofit in this certain circumstance? And so you saw WCA opposed to Assembly Bill 645. I think there were a lot of legislators scratching their heads on that, saying, why would you be opposed to having the authority to grant money to a nonprofit who's operating a food pantry? And we're not opposed to food pantries. We're not opposed to appropriating sums to support food pantries. We're opposed to this explicit statutory authorization because the unintended effect may have been to call into question other programs of relief that counties are operating. So that's an example. So again, and there we've got the fancy Latin phrase that speaks about that statutory construction argument, expressio unius est exclusio alterius. Express mention of one thing excludes all others. And again, it may cause confusion. All right, so WCA came up with a counter proposal to that Assembly Bill 645, and that was actually introduced as a substitute amendment to Assembly Bill 645. And the counter proposal from WCA was that the county may directly provide relief under this subsection or may provide an appropriation to a nonprofit organization for the purposes of funding a program of relief. This relates to the very broad authority in 5953 sub 21, because remember, the Attorney General in that opinion said subsection 21 here doesn't say anything about delegation of authority. It just says that the county itself has the authority to operate a program of relief. We wanted to make clear that a county can provide an appropriation to a nonprofit organization to support that program of relief. And so that was, again, the WCA counter proposal to Assembly Bill 645. Ultimately, what happened is that there was not agreement with the bill author and WCA as to how this should proceed. And so the bill died. It went nowhere last legislative session. Might this come up again? Perhaps. I think it would be really nice to have 59.5321 amended to state what it states here on the slide. Do I think that it's critical for purposes of our analysis? No, but this is one of those things that would be really nice to clarify any confusion that exists out there. So WCA will continue having discussions with legislators. I'm sure at some point a legislator is going to say, hey, wait a minute. Why is it that we still have food pantries excluded from the list of entities that are acceptable for counties to appropriate funds to? We should fix that. And when that happens, WCA is going to have a discussion about what we think that fix ought to look like. So the analysis, this is where we get to brass tacks. So what does all of this mean? Where do we go from here? And I think it can be summed up in these 4 bullet points with a couple of sub-bullets. Is a direct appropriation authorized by statute? If the answer for that to that question is yes, you can stop, full stop. You don't have to go any further. If it's authorized by statute, you can certainly appropriate that money. Second, if the direct appropriation is not authorized, then what is the purpose of the appropriation? Would the appropriation further a county program that exists or the creation of a new county program? And if it's to further an existing program or create a new program, what statute authorizes that particular county program? I'm going to throw this out there and I'm going to make a guess. I immediately said before that I don't know all of the statutes and programs that are enumerated within those statutes that authorize counties to do certain things, but I can have a pretty good idea that cancer prevention is not one of the programs authorized. I suppose you could tie it back to health and things of that nature, but I doubt that when we look at cancer prevention, that would be a specifically authorized program. So that might be one where if the county board wants to appropriate sums to the American Cancer Society, your corporation counsel is going to say, either we can't do that, or if we're going to do that, we're going to have a few dots to connect on getting back to how it is the county has authority to support the American Cancer Society. So again, I'm going to go back to the start of this discussion. That is, counties do not collect property tax funds to redistribute to nonprofits. That's a very basic proposition. But counties do collect tax funds to operate programs benefiting the citizens of the county that they are authorized to operate at the county level. And we certainly believe that there are opportunities to delegate certain aspects of operation of those programs to nonprofit agencies. All right. Next, is it necessary to document the relationship through a contract, a grant agreement, or an MOU? In almost all cases, my answer is yes. I don't know, I'll ask you, Malia, in a moment how you feel about this, but I think a contractual or MOU relationship that identifies the particular county program, identifies what type of services are going to be provided by the nonprofit, so as to support the operation of that program, and then what the nonprofit is going to receive as a result of it doing those services that support the operation of the program. I think that helps connect all of those dots really, really well. Your thoughts, Malia?
Right. I mean, having some type of formalized agreement so that whatever the deliverables are, the services, the program outcomes that the county is looking for is listed somewhere so that you can look at the statutory provisions that allow for contracting with these nonprofits for certain things and tie it to those. The other thing is, it's going to likely come every year in the budget process as the counties go through the budget process. So you're going to have the debate within the budget process and then the MOU as well. So there's going to be two different things. I know some counties, when they're looking at funding other nonprofits where it's explicit, like a battered person shelter, that's explicit in statutes in 59. But they say to those nonprofits, come give your spiel, give your presentation, tell the county board what you're going to do for the citizens, why your services are important. So then you have all of that data, their presentation, the MOU or contract, and the debate as it occurs on the floor when it comes to the budget. And it all supports that relationship is the county exercising its authority under the statute.
And then I think equally as important as that contractual relationship is, to the extent that we've not adequately documented the program, if you will, and the purpose, the public purpose behind that program, let's think about a resolution that either establishes or defines or clarifies whatever the way that the program is intended to operate and how it's going to benefit the citizens within the county. Put that into a resolution form. Because again, everything a county does, I don't care if it's appropriating funds to a nonprofit or running its own program, has to serve a public purpose. The public purpose doctrine is found nowhere in the Wisconsin Constitution, but it's ingrained, it's baked into that Wisconsin Constitution, and courts are going to take a look to ensure that public funds are used for public purposes. So to the extent we are using levy funds or state aid funds to support a particular program or something, you always have to have a public purpose behind that program. One of the things you can do to document that public purpose is to have a resolution on file that speaks to the legislative body's declaration of public purpose. So I think it'd be great to have resolutions that identify the particular program, and frankly, the appropriation to the nonprofit should fit within the boundaries of that resolution and the program that it establishes. As with all of this, I've said this a few times, but this is really important here. It's important to work through this analysis with your corporation counsel. Your corporation counsel is the one who is in tune with all of the questions we've been talking about today, who understands what county authority is and how it is that your particular county operates. And so it's really important to walk through all of these issues with your corporation counsel. And again, if your corporation counsel gets stuck and you have questions, feel free to give us a call, give WCA a call, but start with corporation counsel and have them walk through this analysis with you to make sure that it's been appropriately documented. All right, we are at the Q&A portion. We don't have, as best I can see, any open questions in chat or Q&A. Sarah, I think this is a record because we are actually 11 minutes early in terms of our cut time on this. Typically, we run out of time, but apparently Malia has done so well explaining all of this that nobody has outstanding questions. So I'm hoping that Sarah at some point turns her camera back on to see if there's anything else that we need to address.
Nope, I was just going to give it a moment or two to see if anybody else had any questions. I am guessing maybe your January memo was so thorough that everybody understood it, and therefore there was no need. No need for questions.
At some point, I think people would be interested. I don't know if they'd be interested, but I'd be interested in seeing all of the various drafts of that memo, Sarah, because Malia and I, between our office, we wore a path in the rug going back and forth on this memo. Seriously, I bet it's been through 15 different drafts because every single time we figured something out, that Malia's like, well, wait a second, look at this statute here. We're like, oh my gosh, that belongs in the memo too. And so the more you start digging into this, the more you realize there's a lot of stuff out there dealing with counties.
But isn't that what makes your job fun?
It is, Sarah. Every day.
It was really fun. It was actually a very good time.
All right, with that, I am looking and I'm still not seeing any questions in the Q&A. Oh, hold on. Something just popped up in the Q&A.
All right, let's see here. We've got a question from Eric. Somebody who has administrator experience and human services experience, Sarah. This is a very dangerous one. I haven't read it yet, but I'm sure it's dangerous. Eric says, I appreciate the analysis, can understand the logic behind it, and can agree with it. The statutes, particularly ones referenced in Chapter 46, grant powers and duties to county departments of social services and human services. But I think it's important to point out that the powers and duties are authorized by the Social Services, Human Services Board, and the County Board. It's not an open invitation to act without limits, whether approved or not by the department. It's still up to the county board to decide if a power or duty is acted on in a particular manner. We ultimately limit ourselves based on our own actions as counties. Eric, awesome point. I think that's a great point, and it speaks to the relationship between a social services board or human services board and the county board. A human services board and a social services board have incredibly limited taxation authority. Malia, how much money can they raise in taxes?
Outside of what we're getting from property taxes and in minimal cases.
No, I'm just talking independent of the county board. What can a social services board raise in taxes?
Nothing.
Zero, nothing. The power of the purse belongs to the county board. And so social services can say, oh, we love this nonprofit. It's going to support our program. We're going to have an MOU identifying all the things that this nonprofit is going to do. But unless the county board says, we want to appropriate funds to support your MOU, that MOU is going nowhere. You got to work hand in glove. And so social services board, human services board need to work with county board to make sure that the appropriation is there and it's appropriately documented. So like everything else in county government, nothing can be simple, which again, I love it. Malia loves it. Sarah loves it. Nothing can be simple, but it's all there. So great job, Eric.
And, you know, just adding to that, when we're talking about the limited resources that counties have, and I'm sure there might be some counties that maybe are listening to this right now or read our January memo and said, oh, no, we don't want the floodgates to open where all of these nonprofits are going to come knocking on our door, asking for taxpayer dollars, asking for appropriations from the county. The times when a county board, the policymakers of the county, are going to look at entering into these MOUs or contracts to appropriate these fundings, these appropriations to nonprofits. That should be when the county trying to run that program for relief could be better done and done using less taxpayer dollars by working with a local nonprofit organization. If the county can do it itself cheaper and better, it should do that. And if the county doesn't have an interest in doing a particular program for relief, then they're not going to be looking for those. So it's got to be that nexus where both things fit together. When the value to the taxpayer of that appropriation to that nonprofit will be greater than what the county could have done on its own, trying to run its own program for relief.
Totally agree. Totally agree, Malia. And that kind of gets us into this next question from Christine. She's opening up the Doge question, so we're going to hit it head on. So, any NGO support can be argued as a public purpose, NGO, non-governmental organization. And that's the whole, well, not the whole, but a lot of what Doge is looking at the federal level is some of the NGO support is contrary to either congressional intent or public purpose. As I mentioned, the public purpose doctrine is baked into the Wisconsin Constitution. So I think it depends upon what the NGO or nonprofit is doing with the funds. And to Malia's point, we engage with these nonprofits because we believe that they will do the job more efficiently and perhaps better than we could do it on our own. That's why we engage with nonprofits. But if we just issue a blank check to the nonprofit and say, do with it what you will, that's dangerous. It's dangerous for a variety of reasons. It's dangerous for a public purpose reason because we don't have limitations on what the nonprofit can spend that money on. It's dangerous as a county accountability view from that view because we have to answer to our taxpayers and they're going to say, you just gave $100,000 to this nonprofit that's going out there and doing X, Y, and Z, which is entirely contrary to county purpose. That's a problem. And so that's why, again, I like to see, and I think Malia does too, some documentation of this relationship. I don't care if the statute gives us explicit authority to appropriate sums to support a nonprofit. I still like to see some sort of MOU or grant agreement that says We are giving this money to you to do X, Y, and Z. We expect you to do that with this money. That's very important. All right.
I'd say
So
that
now-
is all. I'd say that is all I am seeing in the Q&A and in the chat. So I think, Andy, if you're good, we can conclude and remind everybody about our May 28th topic, which is
what is our May
the
28th
Judicial
topic, Sarah?
Privacy Act.
Oh my gosh, I've never talked about that before. I'm so excited.
Never, never. No,
Yesterday, Sarah, I gave the, I think, fourth or fifth webinar on that topic to the State Bar of Wisconsin. So yes, we're going to have a reboot on Act 235. And the reason I think it's actually going to be different in May, and I think it'll be better, is because we've been talking about the concept of trailer legislation now for quite a while. We actually have a bill introduced, Senate Bill 169. Now that's going to change because there's going to be a substitute amendment coming in. But by the time we get around to the May in the boardroom, we're going to have an actual trailer bill that we can go through and talk about. So I'm really looking forward to that discussion in May as well.
perfect. All right. Well, Andy and Malia, thank you so much. You did an awesome job today, clearly, but we know that by the lack of questions we got. So thank you so much for your thorough analysis of the topic of appropriations to nonprofit organizations. And we'll see how well you do next month in May
Yeah, we'll do
on the
that.
number of questions we get. So I'm excited for the May topic.
Awesome. Thank you, Sarah, and thank
Awesome.
you everybody for
Yep.
your interest in county government. Thanks for your service.
Yes. Thank you so much. We'll see everybody back in May.
Bye now.